January is National Stalking Awareness Month, and tonight we are continuing to highlight the case of a Jacksonville Beach woman.
So Coles Whalen's stalker is now walking free after the U.S. Supreme Court overturned the man's conviction, ruling that the thousands of messages he sent her while she was living in Colorado were actually protected speech. So what does this mean for cases of stalking here on the First Coast? Our investigative reporter Riley Phillips sat down with a legal expert to get those answers.
And this really adds a layer of protection for those who are committing the stalking, correct?
Yes, many state stalking statutes, including here in Florida and Georgia, use an objective reasonable person test, meaning prosecutors must prove a person knowingly harassed an individual and caused what would be considered substantial emotional distress to a reasonable person. But the Supreme Court's ruling changes that, requiring prosecutors to prove that a person knew his or her communications could be viewed as threatening.
This next song is a love song. It's called Romeo and Juliet.
I was in fear for my life. We thought that he was a very dangerous individual, and many people in law enforcement agreed.
I promised you everything.
Coles Whalen's music career was cut short after spending years dealing with a stalker. That man was convicted of stalking her in Colorado, but a June 2023 ruling by the U.S. Supreme Court overturned that conviction.
I was very sad because I knew that it wasn't just about me.
The justices argued the man's free speech was violated, and prosecutors failed to prove that he knew his statements were being seen as threatening.
I was very surprised to see the Supreme Court add a layer of protection for folks who threaten other people. That has not been the law for many, many years.
I sat down with former federal prosecutor Curtis Fallgetter. He tells me the Supreme Court created a new standard when looking at crimes involving threats of violence. The states of Florida and Georgia both use an objective reasonable person standard. The Supreme Court's ruling changes that.
Now, the prosecutor's going to have to prove that I subjectively believe that my threats were going to be perceived by you as a threat. Now they got to go inside my mind as a defendant and prove that I intended it to be a threat.
In their opinion, the Supreme Court justices argued prosecutors should use a standard of recklessness, meaning, was the speaker aware that his statements could be seen as threatening and still made those statements anyway? Fallgetter says this could lead to other convictions being overturned and could create some challenges for investigators moving forward. But advocates say this should not stop victims from reaching out for help.
There is a lot of co-occurrence between stalking and domestic violence.
Stephanie Brown is the director of community education for Hubbard House, a domestic violence shelter in Duval County. Brown says a common misconception about stalking is if there is no physical contact, then it's not dangerous.
And that is absolutely something that we work to demystify, because stalking can absolutely escalate to physical contact and violence. I mean, in all cases of stalking, there is emotional and psychological violence.
She says victims of stalking often feel like they have lost control of their lives because of their stalker, something echoed by Whalen, who made the decision to step away from performing.
It's much more than a career that I feel like I lost. Performing was such a big part of my identity, and I think it's something that stalking victims and survivors rarely talk about. They lose so much. We lose so much when we're a victim of this kind of crime.
Brown says they often tell victims to trust their gut. If something seems off, they can reach out to Hubbard House and create a plan to get out of the situation.
We will talk to a victim about the possible courses that they can take. We're not going to give legal advice about whether they may or may not have a case. If they want to explore reaching out to police, then we're absolutely going to support them through that process.
I've reached out to both the state attorney's office and the Florida Supreme Court to find out if any cases of stalking are being re-examined under this new standard. Representatives are looking into this for me. Florida's stalking statute still clearly states it is not necessary to prove that the person making the threat had the intent to actually carry out the threat.